I'd like to call to order the 12th meeting, September 24th, 2024 of the Rhode Island Ethics Commission. First item on our agenda is the pleasure of administering the oath of office to our new member, Jill Harrison. So to ask you to stand, please. Thanks. You have to meet with
I, Jill Harrison,
having been duly appointed by His Honor Governor Daniel J. McKee. I can't read this morning.
having been duly appointed by His Honor Governor McKee,
Swear to uphold the duties and responsibilities
swear to uphold the duties and responsibilities
of Commissioner of the Rhode Island Ethics Commission
Commissioner of the Rhode Island Ethics Commission,
as enumerated in the Rhode Island Constitution,
as enumerated in the Rhode Island Constitution,
the laws and regulations of this state, and of this commission,
the laws of this state and the regulations of this commission,
and further to abide
and further to abide
by my own conscience, independence, and integrity,
and further to abide by my own conscience, integrity, and independence
in fulfilling these duties.
in fulfilling these
And I
duties.
so
And I so affirm.
congratulations.
Thank you.
The next item on the agenda is a motion to approve the minutes of the open session held on August 20th, 2024. Motion by Susie, second. Second by Commissioner Todd Peterson. We'll go around the table. Commissioner Severini. Aye. Commissioner Rabideau. Commissioner Strauss. Aye. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Mr. Ritchie. Aye. And the chair votes aye. I need the tally sheet. The vote tally sheets. Yeah, make sure we get that. The next item is the director's report. Yeah. Get your tally sheet. Thank you.
Good morning. First, welcome the new Commissioner Harrison. That brings us up to 8 of 9 commissioners now. I do have word from the governor's office that our final appointment to bring us up to 9 is imminent, maybe as soon as this week. Hoping that by our very next meeting, we'll have 9 commissioners. It's really good news. I'll just note that we are live streaming. The link to the live stream is printed on our agenda. And meeting materials for today, the open session materials are public and are available on our website for anyone who is watching the live stream. The live stream will just be the open session. When we go into executive session, we will close the stream while we're in executive session and reopen the very same meeting. So anyone who's watching, they can just sit tight during the executive session and the meeting will reopen for open session. At the conclusion of today's meeting, we will publish any votes that are taken in executive session on our website. You can also call the commission to find out about it. So then just moving down through the director's report regarding complaints and investigations, we have 9 complaints pending currently. And 3 of those I'll mention down a little further down when we get to financial disclosure. We have 3 complaint matters on the agenda today in executive session, and then 1 in open session, which is a petition for consent. Regarding advisory opinions, we have 4 pending advisory opinions right now, 3 on today's agenda, so we're doing very well there. Regarding APRA requests, we received 10 public records requests since the last meeting. We've fulfilled all of them within 1 business day, which really means the same business day. All of those that were fulfilled related to complaints, which is a lot. But, and then one of them was a request that someone made where we didn't have those records, but we're not the custodian of the records that were sought, so we directed them to the Board of Elections, where I'm sure they were able to get what they need. Briefly on financial disclosure, to date, we've received 4,505 2023 financial disclosure filings. We're at 99.93% compliance. There are 3 statements that are outstanding out of all of those 4,505 complaints, which we've never seen ever in the history of the commission to have only 3 outstanding financial disclosures. We initiated a complaint against all 3 of those people last week. We will probably settle those pursuant to our fine schedule, which we'll be talking about a little later today. But I'll keep you updated as to that. One other significant thing, this is an election year, and candidates also have to file financial disclosure statements. And through the efforts of our staff, as of today, there is not a single candidate in the state of Rhode Island that didn't file their financial disclosures. And again, that's never happened that I can recall in the history of the Ethics Commission. So we're doing really well on financial disclosure this year. But finally, just generally, our next meeting is October 8th. I mentioned that hopefully we will have our news commissioner at that meeting. That's all I have for the director's report. To answer any questions if you have any.
Comment that the efforts to get financial disclosure done has worked pretty well. With education, people should be pleased.
Thanks.
The next item on the agenda are the advisory opinions, and the first one on the sign-up sheet is Mr. Boddington. Please come forward. Have a seat, please. Thank you.
Good morning, Commissioners. This advisory opinion is on the tab A in your binders. Mr. Boddington is a resident of the town of Little Compton. He owns and operates Boddington Residential Services, which is a private entity that provides property monitoring, maintenance, and management to Little Compton residents. Among the services that the company provides is trash collection for those clients. The town does not provide municipal waste collection for its residents, and therefore the residents have to bring their trash to the town's transfer station. And to do so, they can either do it personally or hire someone to do it on their behalf. The petitioner clarifies that he only performs waste collection and disposal on behalf of his clients. He does not have any contract with the municipality. To use the transfer station, the residents are required to receive a sticker that they display on their vehicle. They apply for that sticker to the town clerk. They provide a proof of residency, vehicle registration, and they pay an annual fee that is established by the town council. As a business owner that provides waste collection services, the petitioner is required to receive a trash hauler permit, and he does so every year. He sends a letter to the town council to ask for the issuance of such permit. He is required to provide a proof of vehicle registration and insurance, and then he also pays the annual fee that is established by the town council. The permit is then issued by the town clerk. The petitioner represents that anyone can obtain a trash hauler permit. There is no cap on those permits issued by the town. And currently there is only one other company that also provides trash collection and disposal in town. When using the transfer station, everyone is required to follow certain requirements that are relevant to the disposal of the trash and the separation of the various types of trash. The petitioner represents that he applied for a part-time employment with the town in the position of Director of the Department of Public Works. The DPW Director is appointed by the Town Council, and the position itself is subordinate to the Town Administrator. The position carries flexible work hours and require 20 hours per week. A minor part of the responsibilities of the DPW director includes oversight of the transfer station, management of its day-to-day operations, conducting a risk management assessment and supervision of the activities of the transfer station. The petitioner represents that he was offered the position of the DPW director pending a receipt of an advisory opinion from the Ethics Commission regarding whether he may accept the position without running afoul of the provisions of the Code of Ethics, given that he currently holds trash hauler's permit and utilizes the town's transfer station. The petitioner represents that if permitted to accept the DPW director position while continuing to operate his business and use the transfer station, he is prepared in the unlikely event that any conflicts of interest arise relative to his oversight of the transfer station. He's prepared to recuse from participation in those matters, and they will be handled by the town administrator. Here, just brief overview of the provisions of the code for the benefit of our new commissioner. The provisions of the code that we've reviewed is section 5A and 7A with regards to the conflicts of interest and participation in a public official is prohibited from participating in any matter that would financially impact himself, his business associate, his employer, or his family member. Also 5D, which is the prohibition of use of public office and confidential information received through his public office. And finally, section 5E, no person subject to the code shall represent himself or another person before his own agency or before an agency over which he has supervisory or appointed authority. Here, the petitioner represents that the DPW director has no jurisdiction over the approval and the issuance of the trash hauler permit or over the fees of such permits. Further, the town does not provide municipal waste collection to its residents, and everyone brings their waste to the transfer station and follows the same requirements for disposal of the trash. Finally, the petitioner's disposal of waste at the transfer station does not amount to representation of himself before his own agency, as the term is defined by the Code of Ethics. Accordingly, based on the petitioner's representations and a review of relevant provisions of the Code of Ethics and prior advisory opinions issued, it is the opinion of the staff that the petitioner may accept the position of the DPW director while continuing to dispose of waste at the town's transfer station. The petitioner is advised, however, that if he accepts the DPW director position, he is to conduct his private duties on his own time, outside of his normal working hours as DPW director, and without the use of public resources. Further, the petitioner shall not be afforded any other privileges not available to town residents or other businesses utilizing the transfer station, such as disposal of waste outside of the normal working hours of the transfer station. The petitioner will be prohibited from using his public position to promote his private employment and shall not list his public position as part of the advertisement for his private work. Also, the petitioner shall not solicit clients of his private business. Any persons who have financial interest in his public duties. And finally, the petitioner is advised to either recuse himself or seek further guidance from the Ethics Commission if matters relating to his private business or any of his private clients come before him in his public position. Notice of recusal shall be consistent with provisions of section 36.4.6 of the code. I'm happy to answer any questions you may have.
Thank you. Mr. Bonington, you've heard Pat's presentation. Do you have any questions, comments, or concerns about what you had to say today?
I do not.
Do any members of the commission have questions for Ms. Papa? Do I hear a motion to approve the units presented to us by Ms. Papa.
So moved.
Is there a second?
Second.
Motion by Commissioner Rabideau, second by Commissioner Susie. Commissioner Susie?
Aye.
Commissioner Strauss? Aye. Commissioner Cederini?
Aye.
Commissioner Peterson?
Aye.
Commissioner Ritchie?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Harrison?
Aye.
The chair votes aye. Thank you, Mr. Bennett. Appreciate
Thank you. Thanks. Congratulations.
it.
Thank you.
Item on the sign-in sheet is Joshua Berry.
Good morning. The draft for Mr. Berry is at tab C in your binders. Welcome, Mr. Berry.
Thank you.
The petitioner is a state employee who works as the Chief of Municipal Planning and Programming at the Rhode Island Department of Housing. He's asking whether he may accept other employment, providing part-time town planner services on a contractual basis to the town of New Shoreham. The draft examines Mr. Berry's duties as a state employee against those duties with which he would be tasked in his part-time position in light of a number of provisions of the Code of Ethics. First, pursuant to section 3614(5)(a), as defined in section 7(a), he may not take action in his official capacity for the state that will directly financially impact the town, nor under section 5D may he use his state position or confidential information received through it to obtain financial gain for the town. Next, under section 5B, he may not accept this part-time contractual position with the town if it will either impair his independence of judgment as to his official state duties, or require or induce him to disclose confidential information acquired by him during the course of those duties. The Ethics Commission has consistently opined that public employees are not inherently prohibited from holding other employment that is secondary to their primary position. Several factors are examined when considering potential conflicts. They include the nexus between a person's public duties and the proposed other employment, whether the employee completes such work outside of his normal working hours and without the use of public resources, whether the employee is required to appear before his own state agency as part of his other employment, whether such work is to be conducted outside of areas over which the public employee has decision-making jurisdiction, and whether the employee uses his public position to solicit business or customers. Additionally, pursuant to section 5E of the code, a public employee is prohibited from representing himself or any other person or acting as an expert before the state agency by which he is employed. Finally, under regulation 1.2.1, a public employee must recuse from participation in any matter in which his business associate or employer appears or presents evidence or arguments before his state agency. Mr. Berry began his position at the Housing Department in May of this year. Paragraph 1 of the facts on page 1 of the draft contains the 3 essential duties with which he is tasked. Paragraph 2 identifies the programs that he manages as part of his state duties and a number of other projects to which he contributes for the Housing Department. A comparison of the work Mr. Berry performs in his state role to the scope of work that he would perform for the town, identified collectively in the draft as his contractual duties, is central to the analysis leading to the recommendation in this draft. Those contractual duties for the town would be as follows. First, providing professional planning expertise and support to the town council, the planning board, and other municipal departments as required. Next, reviewing development proposals, zoning regulations, and land use applications for compliance with local ordinances and regulations. And finally, reviewing and evaluating all site plans and subdivision applications to determine conformance and compliance with established regulations and the overall impact on the town's municipal services. Mr. Berry emphasizes that his contractual duties to the town would not involve the housing department. He states that to the extent that he is ever at a planning board meeting at which the topic of the housing department policies or resources is raised, the matter would probably be addressed by New Shoreham's town planner anyway, and not by Mr. Berry. Not all advisory opinions invoke the number of code provisions that this one does. Many invoke less, some invoke more, but applying the petitioner's representations to this particular set of provisions cited earlier. The petitioner's essential duties for the state do in fact involve working with municipalities. Generally speaking, he promotes housing development. Mr. Berry explains that due to its geographic location as an island, coupled with its limited growth capacity, New Shoreham is somewhat of an outlier when compared to the state's other 38 municipalities as far as impact as a result of the performance of Mr. Berry's essential duties for the state. He clarifies that to the extent that New Shoreham's town planner were to communicate with the housing department relative to one of his essential duties, the petitioner would recuse from participation in that particular matter. Similarly, the petitioner explains that only the municipal capacity building training program with which he is involved for the housing department would even apply to New Shoreham and would apply to no greater extent than it does to every other municipality in the state. This particular fact was clarified to me moments ago and would result in an edit to page 2 of the draft. If you were to go to that page and look at the second to last paragraph beginning similarly, it would read as follows with an edit. It starts, similarly, the petitioner explains that only I would seek to cross out one of the programs and replace it with the municipal capacity building training program with which he is involved for the housing department would even apply to New Shoreham. And then the sentence would end there. The following sentence would be eliminated and replaced with that program would apply to no greater extent than it does to every other municipality in the state of Rhode Island. Perhaps I could do that a little more artfully with some more thought, but that's the gist of the change. The petitioner states that the other projects for which he is responsible at the housing department either do not apply to New Shoreham or apply to New Shoreham to no greater extent than any other city or town in the state. Mr. Berry states that his work for New Shoreham would require 20 to 25 hours per month from him, or roughly 4 to 5 hours per week. His hours at the housing department are Monday through Friday from 7:30 a.m. to 3 p.m., which he informs are flexible with the option to work remotely. Petitioner represents that by their very nature, the services that he would provide for New Shoreham as an independent contractor would be conducted outside of areas over which he has decision-making jurisdiction in his role with the housing department. He offers that to date, the town has not applied for any of the programs that he manages or with which he is involved in the context of his state employment. Based on the facts as represented by the petitioner, there is no evidence to suggest that his performance of part-time planner services on a contractual basis for the town of New Shoreham would impair his independence of judgment or create an interest that is in substantial conflict with his public duties. Accordingly, it is the recommendation of staff that the petitioner is not prohibited by the Code of Ethics from accepting other employment in which he seeks to engage, consistent with his representations set forth in the draft, and provided that all of the work is performed on his own time, and without the use of housing department resources or confidential information obtained as part of his state employment, and further provided that he does not use his state employment to advertise or promote his private work or recruit or obtain potential clients. Additionally, Mr. Berry may not appear before the housing department in his capacity as an assistant to the town planner. Further, for the duration of his contractual arrangement with New Shoreham, Mr. Berry must recuse from all housing department matters in which the town or its authorized representative appears or presents evidence or arguments, and from all matters that will directly financially impact New Shoreham to any greater extent than any other state municipality. Mr. Barry is encouraged to seek additional advice from the Ethics Commission in the future to the extent more specific questions regarding potential conflicts of interest might arise. I'm happy to answer any questions or to defer to Mr. Barry as appropriate.
Thank you. Mr. Barry, you've heard Ms. Attorney Berdicius' presentation. Do you have questions, comments, or concerns?
Just want to thank you for your diligent work and congratulate Commissioner.
Members of the commission, does anybody have questions for either Ms. Berdicius or for Mr. Barry? Seeing none, is there a motion? So to approve the advisory opinion, motion by Commissioner Ritchie, is there a second? Second by Commissioner Centerini. Roll call vote. Commissioner Susie,
Aye.
Commissioner Strauss,
Aye.
Commissioner Centerini,
Aye.
Commissioner Peterson,
Aye.
Commissioner Ritchie. Aye. Commissioner Rabideau,
Aye.
Commissioner Harrison,
Aye.
the chair votes aye. Thank you, Mr. Barry.
Thank you.
Appreciate it. The last advisory opinion on our sheet is Sagri Sharma.
You'll find this draft at tab B in your binders. The petitioner is employed by the state as the Capital Projects Fund Administrator in the Pandemic Recovery Office of the Rhode Island Department of Administration. She seeks this advisory opinion because she would like to become a member of the Providence Historic District Commission and wants to be certain that her simultaneous service in both positions would not violate the Code of Ethics. I will not bury the lead under the circumstances outlined in the draft. It would not. Before I offer the reasoning behind that recommendation, I will identify the pertinent provisions of the Code of Ethics. Under Section 3614(5)(a), as defined by Section 7(a), a public official may not participate in any matter as part of her public duties if it is reasonably foreseeable, and by that I mean it is more than conceivable and less than certain to occur, that there will be a direct financial impact by virtue of the public official's activity to the public official, to a member of her family, to her business associate, or to a business in which she is employed or which she represents. Now, the code defines business as a sole proprietorship, partnership, firm, corporation, a bunch of other words, pretty much any other entity recognized in law through which business or profit or not profit is conducted. A business associate is defined as a person joined together with another person to achieve a common financial objective, and a person is defined as an individual or a business entity. The Ethics Commission has consistently determined that the Code of Ethics does not create an absolute bar against simultaneous service for two different governmental entities. Determination is made on a case-by-case basis regarding whether a substantial conflict exists in either public role with respect to a petitioner carrying out her public duties. Looking first at Ms. Sharma's state employment. The DOA's Pandemic Recovery Office is the central office for policy coordination and compliance relating to the state's receipt and distribution of federal COVID-19 stimulus funds. Right now, that translates to the states deploying more than $112 million in American Rescue Plan Act funds by investing almost $82 million in the construction or renovation of multi-purpose community facilities and another $25 million in high-quality broadband infrastructure. One of the things Ms. Sharma does in her job with the state is manage a municipal formula grant program for the construction or renovation of multi-purpose community learning centers to improve education and student performance, provide workforce training, and help residents monitor their physical and mental health. Through an application process that began in August of 2023, the state, as the original recipient of the ARPA funds, then made subawards with a majority of those funds to 19 municipalities to be used on 22 community learning center projects. Petitioner was very involved in the development and implementation of the application process for the grant program. She's also the financial manager of the subgrants, and in that role, She reviews and approves all funding requests to ensure the appropriate use of the funds for their intended purpose. The City of Providence has been awarded a total of $16 million in subaward funds to be used for 3 community learning center projects. The first, $4,884,000 has been designated for the Elmwood Community Center. $3,665 has been designated for use by the Joslin Recreation Center. And finally, $7,765 will be going to the Davy Lopes Recreation Center. Ms. Sharma was recently invited to apply to be considered for potential appointment by the Mayor of Providence to fill a vacancy on the Providence Historic District Commission. This is something that she would like to do and for which she has since applied. But wait, what about those 3 grants that have been awarded by the Pandemic Recovery Office for those community learning centers in Providence? Well, the petitioner represents that not one of them is in a historic district and therefore would not be subject to review by the Historic District Commission. But what about any pending applications to the Pandemic Recovery Office from Providence? There aren't any. The city has actually capped its funding request at the $16 million total of the previously mentioned projects. Petitioner states that the potential for overlap in her position as CPF administrator with that of her prospective membership on the HDC is highly improbable, and support for that position can be found at the top of page 3 of the draft. The Ethics Commission has determined that the Code of Ethics does not consider public entities to be businesses, or the relationship between a public official and a public body, such as a state or a municipal agency, to be that of business associates. 2 previously issued advisory opinions supporting this appear at the top of page 4 of the draft. Here, neither the DOA, which is a state agency, nor the HDC, which is a municipal agency, is considered a business entity under the Code of Ethics. Therefore, neither the petitioner's employment by the DOA nor her prospective membership on the HDC constitutes a business association with either of those public bodies under the Code of Ethics. Accordingly, any impact upon the HDC by virtue of the petitioner's activity as the CPF administrator and vice versa would not be considered impact upon a business associate. Actually, we don't even get that far under the facts of this particular request because none of the Pandemic Recovery Office's 3 grant project locations in Providence would be subject to review by the Providence Historic District Commission. Absent some direct financial impact upon Ms. Sharma, any person within her family, her business associate, or a private employer as a result of her actions in either public role, no inherent conflict of interest would preclude her simultaneous service in these roles. It is therefore the opinion of staff that the petitioner is not prohibited by the code from simultaneously serving in both positions. I'm happy to answer any questions or defer to Ms. Sharma.
Ms. Sharma, you've heard Attorney Berdicius's presentation. Do you have any questions, concerns, issues with that?
I don't.
Members of the commission, does anybody have any questions or concerns to raise with either Ms. Berdicius or Ms. Sharma? Is there a motion to approve the advisory opinion as presented or as presented? Yes, we approved the last one as amended, correct?
Yes.
Thank you.
Is there a motion to approve this advisory opinion as written? Moved by Commissioner Susie, is there a second?
Second.
Second by Commissioner Rapidu. Roll call vote. Commissioner Susie,
Aye.
Commissioner Strauss,
Aye.
Commissioner Severini,
Aye.
Commissioner Peterson,
Aye.
Commissioner Ritchie. Aye. Commissioner Rapidu,
Aye.
Commissioner Harrison,
Aye.
the chair votes aye. Thank you.
Thank you. Good luck.
Next item on the agenda is Enright James E. Thorson, complaint number 2023-7. Discussion and vote on discovery. So
Attorney Kevin Burstill for James Thorson responded.
Jason Grammett for the people, state
And in the capacity as prosecutor.
chief prosecutor of the Ethics Commission.
Before we begin a formal motion hearing, we do not have an objection from the prosecutor, which is perfectly appropriate pursuant to the rules, but I want to know before we start whether the prosecution has an objection to this motion disregarding the allegations of the motion. It's really almost a one-word answer.
Great. No, I don't have an objection.
So we don't have to have a hearing on the merits of the question. Are there concerns about the nature of the request?
I have a couple of observations, just
I
based on.
think because there's no objection, that's okay for us to hear first from Mr. Graham, then you can respond to that. Is that all right?
Of course, thank you.
So just briefly, again, I don't object to the petition for discovery. My observations simply are, number one, I think the commission should know that a request for pre-adjudication or pre-trial discovery and the issuance of subpoenas is very unusual for the Ethics Commission. In my history here, it's never happened, which is about 23 years, and I'm not aware of it ever happening prior to that. That's not to say that it's in the regulations, so it can happen. It is unusual. Secondly, I would just note for the record that the two out-of-state subjects here may be characterized, or at least I would characterize them as victims, if there are victims of the allegations in these complaints. And as the respondent has noted in his petition, they do not wish to be deposed. So I'll just raise that for the commission to understand. And then finally, my last observation is that when we get to an adjudication, one of the things that the parties are expected to do is to create stipulations of fact, where each side will just agree to a set of facts that to expedite the trial so that I think you understand what I'm saying. And I have already proposed multiple stipulations of fact to the respondent in anticipation of him also proposing multiple stipulations of fact. And my expectation would be that I would be willing to stipulate to most, if not all, of the facts that I anticipate the respondent wishes to adduce from these witnesses. Because as I view this case, it's not really one where a lot of facts are in dispute. It's a question of whether you think a violation occurred based on this fact. So with those observations on the record, again, I don't object to the petition for discovery.
Mr. Bristow?
Sure. Well, the first remarks, I think are with the stipulation that the discovery is allowed by the regs and by the Rhode Island General laws. That right has been affirmed by the Rhode Island Supreme Court as part of due process to which the respondent is entitled. So I don't really understand what weight, if any, can be given to the first remark that, gee, this hasn't happened before. I don't know when the last time someone had a full contested hearing before the commission, but Mr. Thorson continues to assert his actual innocence of the allegations that have been made, and we're going to request a hearing. That certainly is allowed. So I really don't understand that statement. Second, my client is charged with the probable cause has been found. I'll use the word charged because since we're victims. But he's charged with failing to timely pay for a lunch that was put on by a vendor in the city of Philadelphia. That's in the most general terms what this is. That's what the allegation is. That's what we're going to attempt to focus on. I think that's the only thing that's the focus of the charges for which cause has been found. I guess I object to the characterization of the word victims. These folks are material witnesses. My client has had absolutely no opportunity to question them. We've attempted to do that through their counsel. We need to do that, and the law allows us to come in and to ask this administrative body, the commission, for subpoena power and the right to take discovery. That's what we want to do, and that's what the motion is all about. The last is, council saying, well, we can stipulate, and we will in good faith, once we have all of the discovery that we are entitled to, and that the law and the rules of this body allows us to take, we will attempt to enter into stipulations if that's the state of the evidence at that time. And, so those are my responses to what was just said by Mr. Barrett. Thank you. Any questions? I'm here.
I'm going to turn to members of the commission. Anybody have any questions?
I apologize. That's all right. Yeah.
Any questions of Mr. Bristow?
I have some thoughts, but I don't know exactly how to articulate them yet, so. I think that, per our regulations, you have the right to discovery here, but beyond that, you need to show good cause for taking depositions, any other discovery mechanisms, right? Under 3.13. Yeah.
He has the right to
Yeah.
take a deposition upon the showing.
Right, of good cause. And then when we cite to, what is it? La Petite Aubergine. I think that that case really discussed when the court can get involved to review the discovery methods before an administrative body. And in that case, it looked like the Human Rights Commission was not going to allow any type of discovery. Here, other than what you're asking for, the other obligations in 3.13, have those been met? Have you requested those documents? Have all those things been produced to you?
Yeah, I mean, we've received from the executive director, accepted, I've been advised, is the investigative file.
Oh.
All the discovery that was generated as a result of the investigation. And I think the La Petite Aubergine, did I say it correct?
I said it wrong. It's not aubergine. I went for it because it was French, but auberge.
I took 8 years of French at St. Kevin's School. I speak about 5 words. But having said that, I mean, I think it's right on point, and I think the language of our Supreme Court could be more direct. And the worst thing, I don't want to sit here and read something to you, but it's 2 sentences, and if you'll permit me, it is not unreasonable to infer that under such circumstances, which is where discovery is denied, but it's not unreasonable to infer that under such circumstances, the hearing will proceed under conditions in which one side has had an extensive period, parenthetically, the investigation, in which to carry on what amounts to full discovery, while the other side has had none. But if fairness is to characterize the hearing, discovery may not be unilateral. And they're talking about more than just like the discovery that we get to view what the commission has done in their investigation, but also that we get to conduct independent discovery. And there's no secrets here. I mean, the cause is, I think we lay it out in a motion, and I'll to a large extent, I'll rely on that. I mean, I've listened to I've watched the video of one interview of the Scout folks, Ms. Canapiccio and Mr. Abitbol. And I've listened to an audio recording of a second interview of the 2 of them together, and maybe the other way around. I apologize, but I mean, there's a lot of issues that, as in connection with representing my client and attempting to get to the bottom of exactly what it is they say happened here, that we need to depose them. We need to get documents from them. There's nothing fancy about this. I know this isn't like civil litigation. It's an administrative body.
Right.
There's
So don't you have
absolute,
to show risk of actual bias and prejudgment, and that's why you need to go above and beyond what the regulation allows for?
right, which is why I think we wrote it. That what we are looking for is, their direct responses to questions that we believe are essential to be able to defend Mr. Thorson in this matter. And I have pointed out concerns that we have as a result of the discovery we did receive from the executive director. And I think that going forward, the only way to go forward for us is to speak to these people under oath and to get their responses. And I don't think that's onerous. I mean, they certainly were willing to do it in connection with the commission. They did it in connection with a law enforcement investigation, the state police. They went to the trouble of hiring an attorney to accompany them for that. And then they were submitted to a second interview with the commission's investigators, you know, and I don't think we're asking for anything that's inordinate, or that's not required to adequately, defend Mr. Thorson here before all of you.
If I might, was 36-14-13 establishes a presumption of innocence on behalf of the respondent. Presumption of innocence. There's been serious allegations against the respondent that has warranted probable cause findings by the commission. From my perspective, where the apparent material witnesses have been identified, having submitted to state police investigations, commission investigations by staff, it seems to me that due process must yield to the respondent so that the respondent may have different questions, a different perspective, so that it's really, if the respondent's attorney feels that these questions need to be asked in full preparation, I believe they should be asked. And I believe that the subpoena should be issued.
You know, the members of the commission have any comment, discussion, thought?
Well, the other question I have for speaking counsel is, this being something of first impression if this goes forward.
Well, in my 7 years here, this hasn't occurred. Correct.
Having said that, based upon what Commissioner Peterson noticed about bias, who makes the determination whether bias is in fact something that's in compliance with the statute?
Well, I don't necessarily think bias needs to be established. I think all that the respondent to Mr. Bristol needs to establish is that there is good cause for the respondent to take the depositions under the regulation.
Yeah, under the regulations. Okay, so again, still subject to the statute. Okay. Well, that also begs the question, the discovery that took place already, is that something that we will have at a hearing before, prior to that evidence that we will have to review under the circumstances, or do we have to create our own discovery?
No, the parties typically, in the contested hearings that we have had, typically agree on some exhibits which will be introduced and a stipulation of facts. Now, that's not the entirety of the evidence that will be presented. There may be some other exhibits that may be presented that you'll have. There may be objections to them. Chair and the body may have to rule on their admissibility. There may be, and there will be witnesses who will testify in addition to the exhibits. So, kind of like any other trial before a court, you're not going to get all of the testimony of the exhibits until the hearing. And there may be issues as to whether or not some exhibits may be omitted.
Understand it.
Any other questions, comments, concerns? I just want to make sure we all understand what you're asking us for. Of course, you're asking us to issue subpoenas to take depositions of 2 out-of-state witnesses and 1 in-state witness, correct?
That's correct.
And you want to, that's for the depositions. You also want subpoenas for the production of documents from the same 3 people.
That's correct. I mean, we could do a deposition subpoena requiring them to produce those documents at the deposition. So it's, whether it's the same subpoena or a second subpoena, the answer is yes.
And those depositions, you don't expect to take in Rhode Island, do you?
No, we've actually retained the law firm in Philadelphia to, whatever legal authority we have here. And there's a question as to whether or not if the commission were to grant our motion, our petition, and to issue an order, I think most likely we would need to take that to the Superior Court of Rhode Island and to get that court to issue letters rogatory, as I understand the process. I stand to be educated on that, but then we need to take those letters rogatory and bring them to the foreign state, which is Pennsylvania, the county, and to get them enforced, you know. So it's not, I don't think it's as simple as taking, I shouldn't say that. I think it's possible that I may be able to take this order, bring it before not I, but a Pennsylvania attorney, may be able to bring it before a court in Pennsylvania, and have it given some full force and authority. I don't know the answer to that, but I told you what I suspect I'm gonna have to do.
Have you discussed that particular problem with Mr. Graham, the out-of-state issue and what you're gonna need for that?
Other than this morning in the hallway, no, and, so that's the extent of it. I really think I'm going to rely respectfully on, a civil attorney who I've spoken with here in Rhode Island and also with, out-of-state counsel in Pennsylvania. I mean, I wish I had a nice, clear, straight answer for you, Mr. Jones, but I don't,
Frankly, I was trying to point out the problems you have, not to get answers.
Yeah.
There are problems here that need to be addressed in paperwork. That I also am not sure that we can issue.
I
think-
do you have any citations to anything of what authority you would possibly have to issue those subpoenas to?
Oh, sure. I apologize to him. Sorry, he's right.
Yeah.
Yeah.
To the folks that live in Pennsylvania. I didn't see anything in your motion.
No, I think that the first step in first phase, sorry to use a silly analogy, but first phase is to get the authority of the commission, as I understand the rules, to take this discovery. That's why I'm here today. Once I have that authority, as I said, I suspect and there's a statute to relate to letters rogatory, and I think it's about 10, 15 years old, something like that. It's modified.
Well, there's a Uniform Act that was passed in 2019.
Okay.
The Uniform Interstate Depositions and Discovery Act, which
Yeah.
I think you'll need to consult.
Yeah. Yeah, so the answer is that I suspect that I'm going to need to, please understand, if I get the authority of this commission, then I'm going to need to go to the Superior Court in Rhode Island and get it to comply with that statute and to issue a subpoena for which I can ask Pennsylvania to enforce pursuant to like a.
I think you're going to need to discuss with your Pennsylvania council what they're going to need from Rhode Island to move forward in Pennsylvania.
But I mean, I'm sorry, it's my position here to ask questions, but I mean, would you agree without the authority of this commission, without this first step, no discovery is possible?
Fully agree. That's why you're here.
And the problem that is my problem, the respondent's problem, if the commission grants the petition, is something that we'll deal with. We have to. I don't know how else to answer. So,
And if we don't, in this may, right, I'm sorry, no, if we don't grant the petition, which is, that's what.
I don't know if I have the ability to go immediately to Superior Court. If I do, I will. If not, then we'll proceed with what we have. And, should we lose?
I think you do have the ability. Yes.
This may be off point, but the prosecution may well face the same issue regarding getting material witnesses to testify in Rhode Island. Because the commission has to make determinations as to credibility, materiality, and whatever. So it seems to me that if the prosecutor says, I'm not going to call A, B, C, and D, this motion may become moot. And if the prosecution is willing not to concede calling A, B, C, D, then I think Mr. Bristow should be on an equal footing with the prosecution to process.
I think the respondent clearly has shown good course here for the commission to grant this petition. And the I didn't take French for a year, so I'm definitely gonna mess up, but the La Petite Auberge case basically says that due process under these circumstances should permit the respondent to take a pre-hearing deposition. And one of the things they do talk about is the ability to effectively cross-examine witnesses at the adjudication hearing. And the need to take depositions so you can properly prepare for cross-examination.
Any other comments, questions? Is there a motion to approve or to grant rather, Mr. Thorson's petition to take discovery as requested for the items requested, disregarding necessarily the allegations, et cetera? I guess the question is there a motion that there's good cause to permit the discovery to be taken?
So,
Is there a second?
check.
Motion made by Commissioner Ritchie, seconded by Commissioner Centarini. Roll call vote. Commissioner Susie?
Aye.
Commissioner Strauss?
Aye.
Commissioner Centarini?
Aye.
Commissioner Peterson?
Aye.
Commissioner Ritchie?
Aye.
Commissioner Rabideau?
Aye.
Commissioner Harrison?
Aye.
The chair votes aye. We're gonna have to figure out terms of an order. Because I think in your concerns about where to go with this, that may make a difference. So I think I'd ask that the council try to get together and figure out what you need to do this. I would point out that Mr. DeSimone and I did some work this morning, and we do look to 917.3 as giving the commission the authority to issue subpoena. Auditors, referees, masters in chancery, and commissioners may issue subpoenas. So I think we have that broad authority to begin with, and so if our subpoena alone is sufficient, it's sufficient. If it's not, you figure out that there needs to be more that we need to do, then unless I'm mistaken, I think that would be an administrative task primarily.
Yes,
That could come directly to the chair for resolution or execution. So I would ask you guys to get together, get us an order that you think does what you need. And if there are issues, I guess we'll see you in a month or 3 weeks, but I didn't think there would be no issues involved, so let us know.
Thank you.
Thank you. The next item on the agenda is a motion to go into executive session to wit. A motion to approve minutes of executive session held on August 20, 2024. Pursuant to our Gen Law section. Oh, I'm sorry, I completely skipped one. Here I go again. The next item on the agenda is the discussion regarding commission regulation 520-RICR-00-00-3.30 and fine schedules for financial disclosure complaints. That, I believe, is an open discussion, and I would like to have it be that way. So I'm gonna sit back and let people talk as they see needed. I know this is a civil group, so who would care to speak first? I think I'm gonna ask Commissioner Centarini actually speak first. This was your concern to begin with.
Yeah. Generally, penalties can be classified in two ways. Punitive or punitive. Punitive being there for punishment. In essence, to get on behalf of the public, a pound of flesh for the wrong done to the citizen. Usually a monetary penalty. Remunerative are to secure compliance and to take into account various factors such as the length of time involvement that the staff is expended to get compliance with the code. So a financial penalty may be dependent either of those factors, punitive or remunerative. My concerns over a period of time is sort of generally referenced by the chairperson has been an understanding, at least on my part, as to the penalties that the commission imposes and how they're reached. I go back to one of my first votes that still troubled me. And the lady who came in and didn't file the report in a timely fashion. New time person to running for public office, thought she was gonna go do the good works of society. An opponent filed a complaint against her, and I think she got hit with a $500 fine. A working mother, that bothered. And since then, whenever I have the chance to raise the issue on penalty, I try to respectfully do so. As I read 3.30, I don't see why there is a distinction in penalty if they're initiated by staff versus the general public. I'm sure that these provisions were enacted in full good faith. And interpreted by the staff in good faith. But I don't see how you penalize because it's initiated by the staff in a lesser way or not in an equal way to initiated by a third party. I'm sure that there's a rational explanation, but I haven't been able to think of it myself. I think, and I'm aware of one case where the state Supreme Court reviewed a penalty post finding a substantive violation. And out of disclosure, that case goes back to 1985. Out of disclosure, I represented the woman. And that's why it comes to mind. And that case was consolidated with the comedy case. Both cases went before the Supreme Court. And in the Luby case that I'm referring to, the Supreme Court reversed a penalty, even though there was a substantive violation, because they ruled that the commission was too rigid. When you look at the statute that establishes the penalty procedures, the overall statute, the comprehensive statute, not 3.30 specifically that deals with fines solely on financial disclosures, because as I read Jason's summary, the commission, even under 3.30, can go in a different direction, go through the comprehensive statute for penalties. And when you read the comprehensive statute, it appears that the spirit of that statute is orientated more towards compliance than penalties. When you go through A, B, C, D in the order, it seems like the General Assembly, in recognition of a presumption of innocence, perhaps, was trying to establish a compliance procedure. And if that didn't work in a remedial nature, then go to the fines, and the fines can go up to $25,000. Recover unjust enrichment and order the vacation of public office. That's the powers of it. This body is extremely powerful. But it seems that remunerative penalty to take, in my perspective. A first orientation before we get to punitive, and especially when you consider the good works of the staff. 99 point something, there's only 3 outstanding financial disclosures. So that's my general feeling.
I would just add that I don't really see a basis for a distinction between who initiates the complaint as well. I think maybe if Jason has any thoughts or on that, I'd like to hear.
Roundtable, so.
Right, so the, the status quo is that the complaints that we initiate on financial disclosure complaints, right, either delinquent, that means they're late, or they were filed late, or they were never filed delinquent, or deficient, which means someone didn't answer a question properly. When we file those, for the late filing complaints, like we just filed for 3, we have this schedule, and there is no schedule, as the judge pointed out, for the other type. I think I completely agree that in many, many cases, the schedule should be the same. Today, we have 2 settlements in executive session on financial disclosure complaints that were filed by third parties. And the settlement we're proposing is consistent with the fine schedule. And that's how we normally prefer to operate. I will say that you might want some time, and we wouldn't object to treating all complaints the same for the most part. But what you do want to keep in mind is that there are those outlier complaints where every now and then someone who left something off their financial disclosure statement did it on purpose. And we had, and I can name names, I can name cases. Ray Gallison, the first time he came before the Ethics Commission, he left off his employment. It was employment with a nonprofit that received a significant amount of its funding from legislative grants. It turns out that's okay. He was allowed to work somewhere that got most of its funding through a legislative grant. But Representative Gallison didn't know that. He thought he wasn't allowed to work for a place that got its funding from a legislative grant. And so he intentionally omitted that employment from his financial disclosure statement. And he admitted to that ultimately, that it was an intentional omission. And I would just suggest to you that, is that a case that you want to allow him to settle for $100 within 10 days of that complaint being filed? We didn't. So now that doesn't happen very often. So I just am suggesting that maybe we need to at least consider some type of safety valve for those types of cases, while maybe treating the vast majority of cases identically, whether they're staff initiated or initiated by third parties. Have no objection to that. And I think it makes complete sense. So
I think that. So in that case that you just explained, the way that the penalties read, even if that individual intentionally omitted something from his disclosure, as long as he says, basically, my bad, I'll fix it within 10 days, you'd be bound by the $100.
It depends on how you structure the schedule.
Yeah.
Same thing, we just had a complaint where a state official left off a half dozen out-of-state trips. Would you prefer that we settled that one for $100? Right. Which we could have done very simply and easily. And maybe that is the right answer. It's just that occasionally we do have those types of cases. And so I want the commission to just be aware of it. Yeah.
Doesn't the current schedule says may, so it doesn't say shall. So is that what the valve is that's built in now?
In the current schedule, the way that we read this schedule, which is attached to the memo, it's the very first schedule after the 3-page memo. That first part, informal disposition within 10
Yeah.
days. As to that, the way we read the schedule is that the respondent has an absolute right to require us to accept his or her $100 if he does it within 10 days.
Even in your example of someone who intentionally omitted.
If this applies, then they have the right to handle it with $100. The second one, the informal disposition more than 10 days, as I read it, there you see the executive director or designee is authorized but not required to settle it for $500. That language does not appear in the first part of the schedule.
I agree with, just for the record, I agree with Jason's reading. It sounds like it's the respondent's option to take the penalty within the 10 days.
Well, under the present,
Under the
they're
current.
only on the ones that they bring. On the current
Right,
regulation.
right.
Just on the ones that we initiate.
I just wanted to clarify what
Yeah,
your opinion
right.
was, that's all. I don't.
Just a quick comment. Based on, the matter we got involved with the last hearing, the 10 days seems to be awful short. The 10 days, when you consider a person getting in touch with the commission notifying them, the 10 days, if there is going to be a 10-day, perhaps should be reasonably extended to get the meetings in, as came forward in last month's meeting.
If I could just respond to that too, I agree, 10 days is a short amount of time. One of the things that I utilize is where I'm authorized to go with to change this in unique circumstances and to for both of these, whether it's 500 or 100, to change that amount in unique circumstances. One of the unique circumstances that I often find is that we find that the respondent did not receive the complaint materials early enough to have responded within those 10 days. So even though maybe 17 days have passed, if I can see that the person was out of state for the first week or there were delays, I call those unique circumstances. And so frequently I will authorize us to go forward with the $100 limit, even on cases that have gone past the 10 days. So just so I'm not saying that's the perfect antidote for the problem you raised, but we certainly do.
Well, I have a few, I guess I'll say comments and maybe concerns. My reading of 3.30 is that there is no distinction between complaints you bring and complaints that are brought by third parties. I don't think that's a fair reading of the reg to say that it only applies to those that you bring. But my concern is the opening paragraph of Rule 3.30, which says complaints shall be processed unless otherwise determined by the commission. And I don't know how we determine whether they shall be processed pursuant to this rule if we don't see them. How are we exercising the discretion that this regulation seems to give to us unless we have a mechanism for things to be brought to us? And if it's the staff or the executive director making the decision what should come to us, they're exercising their discretion. We're not.
Wait, doesn't that mean shall be processed pursuant to the terms of the regulation unless we determine otherwise? Not that we need to like in terms of the process and procedure unless we change the process.
I don't read it that way. The complaints which relate to alleged violations shall be processed pursuant to procedures unless otherwise determined.
Right, like it should be processed pursuant to procedures unless we determine other procedures. You don't read it that way.
I don't read it. I mean, I'm open to the discussion, but that's not how I read it.
On that point though, is there been anything in the past that when this issue has come up, to have it initiated by the commission as opposed to having it received it by the commission? Has this ever come up before? Has the commission ever on its own taken the action. Can anybody answer that question?
I have to turn to staff on that.
Taking the action to,
Initiate a complaint.
well,
They,
we, as the chief prosecutor, I initiate complaints on a, not a regular basis, but on, you know.
I'm speaking of
I
the
issue-
findings that are made by staff that are sent to us. Now, at that point, we'll just be recipient. Has it been a situation where? It begs the question, how will we even have, they don't have the step directly to them. They review it. They make a finding that comes to us for what, approval or rejection. No?
Up to us.
Well, on these filings, they don't come here at all.
On the ones
No,
that
they
we,
come for
There's a
initial
complaint.
determination.
Right, so on that basis, we're looking at the findings of the staff. We have a right to question the staff. And then at that point, we make a determination whether or not to approve or reject.
Not on the informal ones.
none of these, so the,
Okay, so on the informal ones where there's $5 to $100, as the case may be, you're saying, Mr. Chairman, that we should have the opportunity to be, to what? To review those before they make a determination?
I'm not saying what we should do. I'm saying what I read the reg, I see the problem in. And what happens right now is they, under the reg that we have and the schedule that we have, they file a complaint. People respond within 10 days, they settle it, and we don't see it. And my
I don't
point
see-
is
I
that
don't
if
see
that's
that happening.
so, and if I've understood the reg right, and I'm, Commissioner Peterson questions my reading of the reg, which that's fair, I appreciate that.
I don't think you're reading of the regular right or wrong. I think it's there. And I think it's something for, could be, but I think right now, it seems to be a process that's, again, I'm asking, I guess it's never come up before.
Well, that's why I don't think it has come up that I'm aware of, certainly in my time it hasn't.
so the basis, the reason the schedule exists, because we asked, the staff asked you to pass this schedule.
okay.
And the reason we did is because the staff didn't used to initiate complaints. Early on it did. And then for years, the financial disclosure had horrible compliance in the 60s. When I came on board in 2001, I think the compliance rate was around 60% for the whole year. It was a horrible compliance rate. Then Operation Compliance filed 1 year 40 complaints about financial disclosure, which was kind of a wake-up call for us and the commission. And we were short-staffed at the time. And that pretty much consumed the entire staff and the Ethics Commission for that entire year, prosecuting these complaints, doing the investigations, holding hearings in front of the Ethics Commission. In order to have them not file 40 complaints against the next year, we said, we will start initiating complaints again. And we began the process of annually initiating 20 complaints, 25 complaints, however many, to show that we're willing to do this. But that still would have created every meeting there would have been, your executive session would have been loaded with these financial disclosure complaints. And so the commission and the staff reached an agreement where, listen, is there a way to expedite all of these staff filed complaints?
But now there's material change of circumstance. There's 99+% compliance. So when it's a material change of circumstances, should we try to reflect the reality of today?
Why go there? Right now, it's working. Yeah, I agree with that we have to have the reading of the statute, have the authority, so to speak. But right now, the process seems to be working well. I hear you. Right? I'm just saying it's out there, and I see that the chairman respectfully also. So
I certainly think we should be treating all complaints the same. That's my view. I don't see why we should be distinguishing who brings the complaint, how it gets treated internally. So to me, that is one change to how we're dealing with things that I would think we would make. What authority, taking Commissioner Peterson's approach, I think, what authority we give to the staff to informally resolve things is, I suppose, an exercise of the form of discretion that I'm seeing in the reg.
I mean, that's how I read it. It shall be processed pursuant to the procedures set forth in this regulation, 1, 2, 3. I mean,
Unless
unless
otherwise.
we otherwise determine there should be a 4, a 5, and
So I mean, I'm willing to, I mean, maybe we could more artfully phrase it if we were gonna amend this. But I don't know that we need to amend 3.3 instead of or just our schedule. But I think that under our schedule, we probably need to talk about amending it to capture all kinds of complaints. And then we can talk again, and I don't know whether that's appropriate for this meeting, about the time frames that Commissioner Severini's raised.
This time.
And I suppose we could talk about the amount of the fines as well, at some appropriate time. I don't know whether this is. We've had a discussion. I don't think we're taking motions at this point in the discussion. There's nothing for the body on.
I would suggest that we defer and give counsel the opportunity to review the Luby case. I'm sure he hasn't committed it to memory.
Hopefully, yeah.
Well, I do remember that Tom Carmody was also the ULI basketball coach.
So, if I may.
Sure.
So what I'm hearing, and what I suggest is that you give us a chance to, after today, we will come up with a rough new proposed fine schedule that will include all financial disclosure cases, regardless of who filed them. We'll leave some things blank, like time frames and amounts of penalties. Give us a chance to think about some suggestions that take into account the concerns that have been raised. I'll bring it forward to you in a future commission meeting, just for more discussion and for more input as to edits and amendments. This is not something that we have to do in one meeting. Then based on what you say, we can go back and finalize it to bring it to a better draft position. I'll bring it back to you again at the appropriate time. You can vote if you choose to implement that fine schedule.
I think 3.30A1 actually requires that the schedule apply to all respondents. Because the language says the commission shall adopt by a majority vote a schedule of fines and penalties to which a respondent shall be subject if he or she consents to the entry of a finding of a violation. So that would be, I think, the way to go.
Could I request that the staff and council also look at, when I look at A 3.30A and 1, although there's a shall reference, I wonder whether that shall, it says shall adopt is directory and not mandatory. Courts have always said historically shall doesn't mean shall. That's why they until you understand all these contradictory understandings, they won't let you out of law school, but you can't charge them plain English. So if there's an exclusion there, I mean, that the commission can do whatever it feels. That the way I read it, you can go back to the general penalty, up to the 25,000. But the general penalty establishes the priority of remedial penalty, not punitive, some may say.
It's an interesting point. And that goes back to your comments about the distinction between the remunerative and the punitive. And that's something I want to discuss in the next, opportunity.
Are we comfortable with the executive director's proposal on
Yes.
presenting it to us?
Yes.
And are we happy with the conversation we've had? Close this off now?
Yes.
All right. Thank you. Thank you all for your comments.
Thank you.
On to the next agenda item. Now, I'm really gonna be on time here. See, I already said one of these, but I'll go back. Is there a motion to go into executive session to wit, a motion to approve minutes of executive session held on August 2024 pursuant to our general law section 42-46-5A 2 and 4. B, Inmare Santos Javier, complaint number 2024-10 pursuant to our general law section 42-46-5A 2 and 4. Inmare Anastasia Williams, complaint number 2024-11 pursuant to Rhode Island General Law section 42-46-5A 2 and 4. And Inmare Olivia Di Francesco, complaint number 2024-7 pursuant to our general law section 42-46-5A 2 and 4. Is there a motion?
I'll move.
Is there a second?
Second.
Motion made by Commissioner Peters, seconded by Commissioner Susie. No, not seeing.
Did we go into executive?
Not yet.
Not yet. I gotta get my vote done and I can't find my tally sheet.
Just, or do you want to do it by?
I'm gonna go around the room so we get this. Commissioner
We're
Celerini,
not in executive. session.
voting on going into executive session.
All right.
Commissioner Rabbit.
Aye.
Commissioner Strauss.
Aye.
Commissioner
Aye.
Susie. Commissioner Harrison.
Aye.
Commissioner Peterson.
Aye.
Commissioner Ritchie.
Aye.
And chair votes aye. Okay. I know they're just here.